Justice Barrett?
So I think the questions that Justice Kagan asked you are hard because they seem like they're not creating. I mean, you're on your strongest ground when you're talking about her sitting down and designing and coming up with the graphics to customize them for the couple. So let me just clarify exactly what your position is on things that are already created in the past. What if it is plug and play? I don't know that much about website design, so I don't know how it could be plug and play. I'm sure it can be. She does the programming, the coding, she has stock pictures, and she sells that as a product, and the customers, Mike and Henry, or, Lily and Luke, fill it in themselves. Is that protected?
It is not protected in the same way that if you sold a Bible commentary, you wouldn't be able to decide whether the Bible commentary will be burned or it will be used in a church service. The stream of commerce, it's been put in the stream of commerce.
Okay, so why is it different? Justice Kagan said, so maybe you do create customized websites, and you've created one for, Lily and Luke, and then, Mike and Henry see it and say, you've created that already, we love it. We want to buy it. Don't create anything new for us. Just give us exactly what you did for them. Why is that different than plug and play, or is it?
It is different. I mean, first of all, if I take your hypothetical on its face, we would be selling essentially she would be creating a website that's exactly the same with the same pictures and text and graphics and videos of an opposite-sex couple and selling it to a same-sex couple, which seems highly unlikely. They wouldn't use that to celebrate their wedding. So in terms of if you're asking her to change the text, to change the logistics, to change the names, you're changing bride and groom, you're changing the couple's name, we know context changes meaning. Justice Ginsburg said that in Yates versus United States. Even the same words have different meaning. God bless this marriage means something different. My body, my choice means something different to an anti-vaxxer or a pro-abortion opponent or proponent. So in that sense, that's why she would object if she were changing the words in the text. But of course, she would sell the same website celebrating an opposite-sex wedding to a same-sex couple.
Okay, so context changes meaning. What if instead of a graphic designer, she's a songwriter? And she writes a song, let's say, At Last, or Wind Beneath My Wings, or something that people want to dance to at their wedding. And the lyrics are out there, it could be played at a heterosexual wedding, or it could be played at a gay wedding. Once the artist has created that song, can the artist say, but I'm not licensing it to be played at certain kinds of weddings?
No, I don't think the artist could. I'm not familiar with the licensing rules and how all that would apply in terms of the contractual relationship. But in terms of just having a song used at a wedding, assuming that would otherwise be okay, there's no other legal rights, she couldn't. That was in the stream of commerce. But I think it's important to point out that if that artist were being asked to perform that song in a live way, for example, sang at a Democratic inauguration and they were asked to perform at the Republican one, under Colorado's theory, they could be compelled to do so in a number of jurisdictions. 19 jurisdictions have political ideology. And when we think about that, there's no limit to what the government could compel.
Thank you. Ms. Wagoner, can I ask you a question about a heterosexual couple? So, in response to Justice Sotomayor's questions, I took it that your website, where you say, why a wedding website, you go through, and it seems like Ms. Smith was careful to say things like, I fully customize the look, feel, theme, message, color palettes, etc. And then there's the engagement story page, and a page inspired by you and written by Lori that captures and conveys the cherished storybook of your love. So I want to ask you a hypothetical about a heterosexual couple that comes to your client. And their wedding story, that they want to write under the engagement story page goes like this. We are both cisgender and heterosexual, but that is irrelevant to our relationship, which transcends such categories. We knew we were soulmates from the moment that we met, and on and on. Would your client publish that site?
Yes, she would publish the site, because her objection, assuming that the marriage is between a man and a woman, she would publish it, and that there's no message.
Even though that narrative, I assume, is inconsistent with her biblical views about marriage. Or I'll give you another related one. A heterosexual couple comes to her, and in the engagement story part, writes a story that goes like this. We met at work. We were both married to other people. But what began as late nights at the office quickly turned into love. After 6 months, we realized we could be happy only with each other. So we decided to begin our story today, got divorced, and are marrying each other. Does she publish it?
I don't believe that she would. I also don't believe that she would embrace or express a message that would essentially say it doesn't matter whether there is a marriage between a man and a woman. She wouldn't create that speech
So it's
either.
about the message and not about the sexuality of the couple that asked her to express it that matters.
Yes, which is exactly how the court decided the case in Hurley, but it's also in other cases as well. The Pacific Gas and Miami Herald cases, this court has routinely looked at compelled speech cases to determine if the message...
And Ms. Wagner, can I just ask you to clarify before we move on? When I first asked you the question about the cisgender heterosexual couple, you said you thought she would publish it, but then it seemed like you wavered and said something different.
If I could
a minute
just
ago.
clarify the hypothetical, the second part of the statement was that it didn't matter. Is that?
That concepts of gender or, sexual orientation were irrelevant to their relationship because they believe that those categories don't matter. What matters is their union of souls.
No, that she would not create a website that would say that because that would violate her beliefs about what Scripture holds on marriage. In the same way, though, this law and the compelled speech doctrine protects the LGBT website designer who won't be forced to have to create a website essentially advocating for a view of marriage that they don't hold.